The auctioneer's hand was already rising, gavel poised, when a voice cut through the murmuring crowd. "Wait, 1 minute. That's all I'm asking." Every head in the courtroom turned. Emma Whitfield walked forward from the third row, calm despite the chaos rippling around her, and set a worn manila envelope on the clerk's table without a word. The bank's attorney smirked, clearly unimpressed. Then the judge reached for it himself, and the smirk disappeared fast. Silence swallowed the room whole. Before we go further, where are you watching from today? Drop your city below. Paper rustled as the judge opened the envelope, scanning the first page, then flipping back to reread it. His expression barely shifted, but the way his eyes moved, slow and deliberate, told everyone something in that room had just changed. 9 years earlier, Carol Whitfield had nearly lost this same 1,200-acre farm once already. A brutal winter wiped out half her cattle. Grain prices collapsed the same season her equipment loan came due, and by spring she owed the bank more than the land could reasonably generate in 2 good years combined. Bank officers offered her a restructuring plan. Extended terms, lower monthly payments, breathing room to recover. Relief washed over her at first. Then she read the fine print twice and asked for something most borrowers never think to request, a written forbearance clause specifying that as long as she made partial payments during any declared agricultural hardship year, the bank couldn't initiate foreclosure without 30 days written notice and a formal hearing. "That's not really necessary," the loan officer told her, visibly annoyed by the delay. "We're trying to help you here." Carol didn't budge. She'd grown up watching her own father lose 40 acres to a bank that changed its story the moment a handshake deal became inconvenient, and she'd promised herself she'd never let that happen twice in one family. Eventually, the officer relented, added the clause, and had it signed and notarized the same afternoon. For years, that page sat forgotten in a fireproof lockbox in Carol's bedroom closet, tucked beneath old tax returns and a stack of unused checkbooks. She never mentioned it again, not to her daughter, not to anyone. It was insurance she hoped she'd never need to use. Cancer took Carol 18 months ago, fast and without much warning. Emma inherited the farm, the debt, and a version of her mother's finances she barely understood. Grief consumed most of that first year. Paperwork came second, third, sometimes not at all. 6 weeks ago, a foreclosure notice arrived, citing 3 missed payments during a drought year that had crushed nearly every farm in the county. No 30-day hearing was offered. No mention of any hardship clause appeared anywhere in the notice. Emma called the bank, confused more than angry, assuming there'd been some mistake. There hadn't been. According to the loan servicer on the phone, her mother's account showed a standard agricultural loan with no special provisions attached. Whatever her mother might have mentioned once, years ago, wasn't reflected anywhere in their current system. Emma had no reason yet to doubt them. She didn't know about the lockbox. She didn't know about the clause. All she knew, standing in her kitchen holding that letter, was that the auction date was already set, and she had less than 6 weeks to stop it. 6 weeks felt impossibly short once Emma actually started fighting. She hired an attorney, a young woman named Priya Sandhu, who worked mostly on small-town property disputes, and took the case at a reduced rate once she heard the details. Priya requested the bank's full loan file, hoping to find something, anything, that contradicted their version of events. Nothing came back useful. The bank's records showed a clean, standard loan with no restructuring history beyond a routine rate adjustment years earlier. No forbearance clause, no hardship provision, just missed payments and a straightforward path to foreclosure that, on paper, looked entirely legitimate. "I'm not saying we can't fight it," Priya told her, 2 weeks before the auction. "I'm saying, without documentation, we're fighting a losing argument. Do you have anything of your mother's letters, files, anything mentioning a special agreement?" Emma didn't, or at least she didn't think she did. Her mother had never been one to talk business at the dinner table, and in the chaos of the past 18 months, Emma had barely touched half the boxes, still sitting in her mother's bedroom closet. If you're just joining here, quick pause. Go ahead and subscribe now, because what Emma finds the night before that auction is exactly the kind of last-minute discovery that changes everything, and you won't want to miss it. All right, back to the story. 3 nights before the sale, unable to sleep, Emma finally forced herself into that closet. Grief had kept her out of it for over a year. Every box felt like it might hold something that would break her all over again. She started with the easy stuff: old photographs, church bulletins, a drawer of buttons her mother never threw away. Then, near the back, Behind a stack of folded quilts, she found a small fireproof lockbox she didn't remember ever seeing before. It wasn't locked. Inside sat a handful of documents, deed copies, an old will, a savings bond long since matured, and, near the bottom, a single stapled packet, with her mother's signature on the final page, dated 9 years earlier, notarized, official. Emma read it once, not fully understanding. She read it again, slower this time, her hands starting to shake. A forbearance clause, 30 days written notice required, a formal hearing guaranteed before any foreclosure could proceed. None of that had happened. Not the notice, not the hearing, nothing. She called Priya at 11 that night, voice trembling, barely able to get the words out clearly. Priya listened, asked her to read the document twice more, and finally said the words Emma needed to hear. Emma, if this is real, and it's notarized like you're describing, they may have foreclosed on you illegally. Bring it to court. Don't say anything else to the bank before then, just bring it. The courtroom fell silent as the judge finished reading, set the document down, and looked directly at the bank's attorney. Counsel, are you familiar with this forbearance agreement? The attorney shifted, clearly caught off guard. Your Honor, we have no record of any such agreement in the client's file. That may be, the judge said. But this document appears properly signed, dated, and notarized 9 years ago, by a bank officer, whose name matches your institution's records from that period. I'd like it verified immediately, before this auction proceeds another step further. A tense 15 minutes followed. Priya had anticipated exactly this moment, and arrived prepared. She'd already contacted the county recorder's office, and secured independent confirmation that a notarized document matching this description had been filed, though apparently never cross-referenced into the bank's more recent digital loan system. The notary herself, still practicing locally, was reached by phone and confirmed, without hesitation, that she remembered notarizing paperwork for Carol Whitfield 9 years earlier. This was the moment the entire case turned. Because the forbearance clause wasn't simply real, it was independently verifiable. Sitting in public records, the bank itself had apparently overlooked, or failed to properly transfer, when Carol's loan was later migrated into a newer digital system. The bank hadn't just made a mistake. They'd foreclosed on a property while ignoring a legally binding protection they themselves had agreed to nearly a decade earlier. The judge's tone hardened. This foreclosure proceeding required 30 days written notice and a formal hearing under the terms of this agreement. Neither occurred. On that basis alone, I'm halting this auction immediately, pending a full review of the bank's compliance with its own contractual obligations. The gavel that had nearly ended everything moments earlier came down instead to stop it. Gasps rippled through the courtroom. The bank's attorney sat frozen, flipping through his own files as though searching for an answer that clearly didn't exist there. Emma stood at the front of the courtroom, gripping the edge of the table, barely processing what had just happened. Months of fear, of grief stacked on top of grief, of watching everything her mother built teeter on the edge of disappearing completely. All of it paused, mid-fall, because of a single page her mother had quietly tucked away 9 years earlier, and never once mentioned. This is the heart of the entire story. Carol Whitfield never set out to become a cautionary tale about corporate paperwork. She simply remembered, from her own father's loss decades earlier, that promises made by institutions only mean something when they're written down properly and kept safe. She protected her daughter without ever telling her she'd done it, trusting that if the day ever came, the proof would still be there, waiting. It was. And it arrived with less than 60 seconds to spare. The formal review took another 2 months to complete, during which the bank's legal department scrambled to explain how a properly notarized forbearance agreement had never been incorporated into Carol Whitfield's active loan file. Internal records eventually showed the omission stemmed from a systems migration 7 years earlier, when thousands of older loan documents were digitized, and, in the process, several handwritten or manually attached clauses, including Carol's, were never properly re-entered into the new database. Regulators reviewing the case found this explanation plausible, but far from exonerating. A bank, they ruled, remains responsible for honoring agreements it signs, regardless of later administrative failures on its own end. The foreclosure was formally voided, the auction results nullified, and Emma's ownership of the 1,200 acres was restored completely, along with a court order requiring the bank to cover her legal fees and formally correct her mother's loan file to reflect the original protections. News of the case spread quickly through the county. first through word of mouth, then through a short piece in the regional paper. 2 other local families, hearing the details, discovered similar clauses buried in their own old paperwork, protections they'd forgotten existed, or never fully understood applied to them. Neither case involved active foreclosure, but both families quietly renegotiated updated, properly documented terms with the same bank shortly afterward, wanting to avoid ever finding themselves in Emma's position. Emma kept the farm running, awkwardly at first, learning skills her mother had spent decades mastering. Neighbors who'd known Carol for years stepped in more than Emma expected, several of them mentioning, almost offhand, that Carol had always been the careful one, the woman who read every line of every document twice before signing anything, no matter how many people around her rolled their eyes about it. She used to tell me paperwork was just a promise written down, so nobody could pretend to forget it later, Emma said, in the only interview she agreed to give. I always thought that was just something she said. I didn't realize she actually lived by it. The lockbox itself, still sitting on Emma's kitchen counter months later, became something of a fixture in the house, a physical reminder of how close everything had come to disappearing, and how a single quiet decision made nearly a decade earlier had been enough to stop it. Emma started keeping her own copies of everything now, in that same box, in the same closet, continuing a habit she hadn't known her mother started until it saved her. Carol Whitfield never lived to see her daughter stand in that courtroom, envelope in hand, seconds from losing everything her family had built. She simply believed, quietly and stubbornly, that protecting the people she loved sometimes meant preparing for a fight she hoped would never come. 9 years later, it did, and she'd already won it, long before Emma ever knew there was a fight to have. Emma stood on the porch that evening, envelope pressed against her chest, looking out over land her mother fought twice to protect. She didn't need to say anything. The quiet was enough. If this reminded you that preparation can outlast even the worst moments, subscribe for more stories like it. Tell us below.